Today, we are in the 68th Judicial District of Dallas County, Texas, in the courtroom of Judge Martin Hoffman, who we have never seen before and has some interesting cases on his docket. This one is a good life lesson on why you don't go into business with family. Enjoy.
All right, let's go on the record on, and everyone's here that needs to be here, is that correct?
Yes, Your Honor, for the plaintiffs.
All right, let's go on the record on DC 23-20183, Mauricio versus Velez. Counsel, make your appearances.
Victoria Barboza for the plaintiffs.
Right, let's,
Bianca Velez.
And Jared Velez.
all right, let's proceed.
Your Honor, I'm going to give a brief opening if that's okay with the court.
Sure.
Your Honor, we're here on a temporary injunction. We're asking the court today to restrain the defendants from operating under the business name Immediate Solutions LLC and using the EIN number that was allocated to Immediate Solutions LLC. We believe the evidence is going to show that the defendants have used Immediate Solutions LLC to apply for loans, federal loans, without the knowledge of the other members in the business. The evidence will also show that they opened up an account for those funds to be deposited. The funds deposited were over $200,000. The evidence will also show that my client became aware of it once she received mail correspondence to her address, immediately started an investigation because it could have possibly been identity theft. But then she found out that it was actually applied for and received by the defendants Jared Velez and Bianca Velez. And Your Honor, I'm not sure if the defendants are going to give an opening, but I would like to call my first witness.
You guys are allowed to make a brief opening as well.
We're basically here to ask you to deny the request for the temporary restraining order. We have proof here of actually Oralia transferring over her ownership to Angela Mauricio. So, and actually Angela, company taxes not even being filed for 2019 in Oralia's name because she did transfer over her ownership. So we're here to deny the request for the TRO.
You're saying that,
Ask to the, yes.
so let me make sure I understand what you're saying. So they have a company, it is, sorry.
We had a company, it was Immediate Solutions LLC.
Okay, so
That was-
who initially owned the company?
It was Jared Velez and Oralia Mauricio.
You guys owned it, and then you're claiming that, what are you claiming exactly? It was transferred?
It was transferred within, actually on February 7th, 2019, we had a minutes meeting with our CPA.
Okay.
And we had, Oralia wanted it out of her name. And it was then transferred to Angela Mauricio. We have signatures, everything to show that.
And who is Angela? What is
She's our daughter.
you? Okay.
And in 2019, taxes were filed for the company with Angela. Oralia wasn't even.
How does that impact what's happening now? They're saying that you guys are using the EIN number to
Well,
get
because
loans.
I'm sorry, because they're requesting a temporary restraining order for a company that she transferred ownership to.
She has no ownership.
She has no ownership.
Angela's also a plaintiff.
But Angela's also, okay, but Angela's also a plaintiff.
Yeah, but all over the paperwork, it's Oralia Mauricio that is actually, it's Oralia.
What paperwork are you talking about?
What we were served with, I'm sorry.
Okay. But she's also, but this person is also Angela is also a plaintiff.
Yeah, and we also have proof of why the company actually had split up because of purchases that were being used, and we have those totals as well. And so when that came about, that's whenever
But have y'all been taking out loans with this EIN number?
What we did was, I'm sorry. What we did was, yes, we didn't take out a loan in 2020. We applied for the PPP loan. And I had applied for it on behalf of the company. and we received it. And then later on that year, I got it. I applied for forgiveness, and we got it forgiven, 100% forgiven. And then later, the business, we separated in 2020, January of 2022. We went our separate ways due to mishandling of funds on their end. And so in the year of 2023, I did submit an application for employee retention credit. But before we paid, when we separated businesses and when I was separated in January, we paid her off, and we haven't texted
But
and
who
emailed.
owns the business now?
Me and her own it right now. We own it as of September of 23 solely, just us two. And I only did that just because of our previous conversations that we would pay her remaining money, and she would give her rights up to the business. And we have it in text and emails, her
Agreeing
accepting the
to.
money and saying that she's no
Okay,
longer a part of the
that's,
company.
that helps me. So let's go ahead and call your first witness.
That was a little confusing, so let me give you a little more background so you understand what's going on. The people involved are a family. The grandmother is Oralia, the daughter, Angela, and then granddaughter, Bianca. Her husband is Jared. Now, Oralia and Jared got together and formed a business called Immediate Solutions LLC in 2019. They were each 50% owners. Daughter Angela and granddaughter Bianca were employees of the company. Oralia used her own money, $3,000, to enter into an office lease for the business and to purchase laptops. The business was an employment staffing firm, like a Ready Work, or I can't think of the other names, but a staffing firm. Nothing related to the business agreement between the parties was put into writing. It was all verbal. About a year after starting the business, they applied for and received a PPP loan. According to the website, the amount was $130,000. According to the court documents, it was over $200,000. So there may have been additional loans on the local level or from other sources that were not directly the PPP loan, but it was at least the $130,000. Oralia and Angela are alleging that Bianca and Jared withdrew $6,000 on 2 different occasions and used that for personal expenses. Oralia is concerned that this is not above board and there could be liability. Without Oralia's knowledge, Jared filed a statement of change of registered agent and added Bianca as an agent for the company and removed Angela, who had previously been there. And that is part of all of the dispute. Is basically, it looks like every time I say basically, I think Judge Judy would be so mad at me.
I don't want to hear basically.
Angela and Oralia are trying to ensure that everything is done correctly, and Jared and Bianca are trying to take the business over. So this suit was filed in 2023. It is just now getting a hearing. There was multiple hearings that were scheduled but were canceled for various reasons. This is a hearing to issue a temporary injunction against Bianca and Jared to prevent them from conducting any further actions in the name of the company, which Oralia is still tied to. I am going to upload all of these documents, all the documents related to the case, all of the filings in Patreon. So if you'd like to read them, head on over there.
Thank you, Your Honor. Your Honor, my first witness would be Oralia Mauricio.
Okay. I understand you're a little tight for time, so you got to move quickly.
Yes, understood, Your Honor.
Please raise your right hand. You swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Please be seated. All right, you may proceed.
Thank you, Your Honor. May you please state your name for the record?
Oralia Mauricio.
And what is your relationship with Immediate Solutions LLC?
I'm a 50% owner,
Okay, and when did you form Immediate Solutions LLC?
when did we
Do you remember
form?
what year?
Yeah, in 2019.
Okay. And who else was a name manager along with you?
Jared Balez,
Okay, and what was the percentage of ownership?
50%.
Okay. And can you please let the court know what was your relationship? What is your relationship with the defendants?
His wife is my granddaughter.
So therefore that makes Mr. Velez.
Mr. Velez, my grandson. Yes, it does.
And did you and Mr. Velez open up any bank accounts for the Immediate Solutions LLC?
Yes, we did.
Okay, and what bank account was opened?
Bank of America, National Bank of America.
Okay, and did you also open up an account for First National Bank? For Immediate Solutions
Yes.
LLC? Okay.
Yes.
And can you please state whenever you found out there was misused funds out of First National Bank, First National Bank?
It's because the CLO, or that man that used to do their taxes and stuff, he told me that they were using the funds to buy a house, and they were taking money out of the account that I didn't know nothing about,
And those funds that were in that account, where did those funds come from?
from Immediate Solution.
And were they funds that were received through the SBA PPP loan?
Yes,
And did the SBA authorize you to use that or any member?
no,
to
they
use
didn't.
that?
They said that they got those funds for the company, not for personal use.
And you found out that Mr. Velez and Ms. Velez were using it for personal?
Yes,
And about how much did they withdraw for that personal use?
the first time that we went, that I didn't know nothing about it. I did not know nothing about what they were doing or anything. I was never told. Then, when I started looking at the bank accounts, I saw that $6,000 came out first. And then another $6,000 came out like a couple of weeks later. And then later, I think a month later or so, $15,000 were taken out of that account.
And then more recently, did you find out that after they stated they were going to dissolve the company, did you find out they were still using the company name and the same EIN?
Yes, when we had an agreement that they cannot use that name anymore, and we couldn't use that name anymore because she wanted my daughter out of there.
And what did they use the name and the EIN number for?
For personal use too.
Okay, and how did you find out that they were using it? How did you become aware?
The reason I came aware of it, I went into my mailbox and then I saw that there was Immediate Solution letter. So I didn't open it because I never have opened mail. I've always let my daughter open the mail. So when she got home, I told her, open the mail. I said, we got another thing from Immediate Solution. So she opened it, and when she opened it, it was $200 and something thousand.
Okay, and with that statement that you received from the bank for Immediate Solutions, the deposit slip was in there, and who did they say the funds were received from?
From who sent them to them?
Mhm.
Yes, the IRS.
Okay, and when you say your daughter opens your mail, are you speaking of?
Angela Mauricio.
Okay. And are you asking the court today to restrain Mr. and Mrs. Velez until this case can be heard at trial and from using the name, from incurring any additional debts, and for applying for any loans that you could possibly be responsible for?
Yes, I am.
Nothing further for this witness, Your Honor.
Any-
I have a few questions. Am I able to question her?
Yeah, so let me explain how this works. You have an opportunity to cross-examine their witnesses. You're each separate parties. They've both been sued, correct?
They're suing the both of us, yes.
Yeah, so each of you can ask questions.
Okay.
All right.
I have a question in reference to the $15,000. Angela did not receive $15,000
No,
to
she-
build a back house in her back.
Objection, Your Honor.
No, she didn't. Oh,
Let me just explain how this works. Wait, let me explain how this works. You're allowed to ask her questions. You're not allowed to argue with her.
Got it.
If she objects, then you need to let me rule on the objection.
Right.
So don't just jump in with an answer. I have a feeling you two want to argue with each
no, I
other.
don't.
This isn't a TV court. As in Judge Judy, I'm not gonna allow that. You ask questions, she answers the question. If she objects, then I'll rule on it.
Got
So
it.
let's try that again. You ask your question, you're going to object, and then let me rule on it. So let's try it again.
Okay. Oralia Mauricio, were you aware that funds were also withdrawn from the account by yourself? We have those withdrawals, sir,
Ask questions.
of to allow Angela to build a back house in your back home. Were you aware that those funds that she?
You already asked a question. Are you objecting to that question?
Yes, objection, Your Honor,
And why are you objecting?
because it is a compound question.
Overruled. You can answer the question.
She did open, Angela Mauricio did build a house from in the back, but it was from her money that she had saved from the other job she had.
I also have,
No, you're asking questions.
so when I pull a bank statement of a withdrawal from Oralia Mauricio for $3,000, are you able to provide what you used for that?
I did not pull no $3,000 out.
Okay. Also,
If you have proof of that, you can show it to her and then we
Okay.
can, you can ask her about it.
okay, I have a question. Am I able to?
Yeah, you want to show that? Can you show it to me? Okay, go ahead. Go right there.
One second. No, this is not the one that I'm looking for. I want the one where she talks about the $7,200. Am I able to put your cell?
Right there. It'll show right up there.
So I do have text messages between Angela and myself, where she is.
Objection, Your Honor. She's questioning, Ms. Oralia.
You need to ask questions. You're going to have a chance to testify yourself and you can make your argument. If you have a question for her, you can ask her questions. You don't have to ask her questions.
No, I do. I want to ask her here. In the text message here from Angela to myself, I wouldn't take it if I didn't need it. Trust me, but I need the three, unfortunately. Yes. Mama told me yesterday they had no more money. And when I reference Mama, Your Honor, that is what what we used to call my grandmother, was Mama. So that's us referencing the money was taken out.
But remember, you're asking a question. Stop arguing. So go ahead and answer the question. Was that a text message to you? And
No, it wasn't, not to me. I didn't know nothing about it. That is not my message.
Oralia, is this you on January 17, 2022, going into First Convenience Bank and stating that you wanted to close the account and withdraw $2,577.65?
you got to show it on the screen. Look at the screen up
Oh.
there.
Is that your handwriting, your signature?
Yes, it is. Yes, it is. I did go close the account because y'all had taken all the money already out.
So, we taken all the money out of the account, but yet here it states, correct me if I'm wrong, Oralia, a closing account because we believe someone has access to these who are not authorized on the account.
That's
So
right.
that was false, what you just stated, right? You said that we were closing the account because we had already took all the money out of the account. That's false, correct? Because here you state that you're closing the account because you believe somebody who has information who is not authorized on the account. Is that correct?
That's correct.
So there was money in the account when you
2,000.
went to close it. And am I correct that you went to close it because you thought someone had access to the account and it wasn't because there was no money in the account that was taken out by Jared and I?
It was $2,500, which you called Angela Mauricio and you were crying because you didn't have no money to pay the employees. So she gave it back to you.
That's false information as well. I have a text message here.
Or-
Okay. On 4/18/2021, here is a withdrawal slip, Oralia Mauricio, for $3,000. Is that correct? Is that what you see on the screen?
I think that those $3,000, you told me to go get them. I don't remember, I do not remember me getting any money for my personal use to do anything. And you know that.
It wasn't for your personal use. That's not what I'm accusing you of, Ms. Mauricio. I'm asking you if you withdrew these funds.
I don't remember.
You don't remember. Is that your signature here, Oralia Mauricio, on the bank statements? We cannot forge that signature, and this is from bank statements that we have pulled in from the account. Is that your signature?
That is my signature.
Thank you. Also, again, on May 7th, 2021, we have another withdrawal from Oralia Mauricio, and that's yourself, correct?
Yes,
Correct, okay, and that was on May 7th, 2021, correct? $3,000. I have also a text message between myself and Angela, actually in May, that I will be able to give you here. That Angela states that she's going to have Oralia
Your
Mauricio
objection.
go
The witness
withdraw.
can't testify as to a text message between Ms. Velez and
You probably want to talk to Angela.
I will
about
go ahead and say that, we
You're
have-
asking questions of this witness.
we have any-
If you don't have any more questions, that's okay.
I'm okay for now.
Okay. Do you have any redirect?
Yes. Ms. Mauricio, as a manager of Immediate Solutions LLC, are you authorized to do transactions for Immediate Solutions LLC?
yes, I was.
And in those transactions, you're able to deposit, you're able to withdraw funds. Is that correct?
That's correct.
No further questions, Your Honor.
Any other questions for this witness?
No,
You may step down. Call your next witness.
My next witness would be Ms. Angela Mauricio.
Okay, please take a stand. Please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth? Please be seated.
Can you please state your name for the record?
Angela Mauricio.
Okay. And were you an employee at some point of Immediate Solutions LLC?
Yes.
And like Ms. Velez did state in her opening that the company was transferred to you, that is correct?
It was in process of it. From my understanding, our CPA was, we asked him to do it.
Mhm.
It was never filed.
Okay. And when you guys discussed that transfer, did you take, some duties, like as far as?
Well, wait, so let me understand this then. So who actually currently owns the business?
Oralia.
But it was gonna be
Object-
transferred to you?
It was going to be transferred. The CPA was done with us because of Ms.
So your
Velez.
position now is that Aurelio is the sole owner of the business?
From my understanding, yes.
And can you please state the relationship to the co-plaintiff?
My mother,
Okay. And did you help run the business with your mother?
yes.
Okay. And did you find out of any misuse of the funds?
Yes,
And did you approach the defendant, Ms. Velez or Mr. Velez, regarding the misuse of the funds?
yes, some I did.
Okay.
In person and through text.
Okay. And is there a text message that you had with Ms. Velez that stated that she was dissolving the company?
That we were both gonna dissolve. That was the last text that I am aware of that we have, that I told her that the plan was for us to dissolve the company.
Okay. So I'm gonna show you what's been previously marked as plaintiff's exhibit 8.
Mhm.
Can you please, is this a text message you received from Ms. Velez?
Yes,
And can you state whether you're gray or were you in the darker?
I'm gray and she's the darker
Okay,
color.
so what did Bianca tell you in this text?
There's no way to pay the 12,000 or even 9 upfront, so the business can't dissolve. I will take my clients and move on. I've already talked to them today.
So did you believe after this text message that she was dissolving the company?
Yes.
But did she in fact dissolve the company?
No.
What,
Let me ask this, I'm a little confused. So how is she able to dissolve the company if Aurelio owns the company? I'm confused by that.
she was working through her husband as proxy. So,
Who was working through that?
I'm sorry, Ms. Velez and Mr.
But
Velez.
they didn't own it. According to your client, she just testified the sole owner was Aurelio. How could somebody who wasn't an owner dissolve the company?
So she was not the sole owner. They're 50-50
She
managers.
just testified that
Okay.
Aurelio was the sole owner.
No, she's 50 and 50, 50 and
Who's
50.
the
I
other
believe.
50%?
Mr.
Mr.
Velez.
Velez.
So he is, and that's currently the case.
Currently, me and her are the owner.
According to y'all, who are the owners currently?
Currently,
You need to understand, when I ask you, when your attorney asks you a question, you need to tell the truth. When I ask you a question, you better tell the truth. And you didn't tell me the truth. You said that Aurelio was the sole owner.
Oh, I misunderstood that part. Yeah, no. It was
Do
50,
you understand
50.
how that affects your credibility here? Is when I ask you a question, I'm the one wearing the black robe. You told me something that was not true.
Right.
So everything else you say now is going to be called into question. So when you get a question, you make sure you listen to the question, you answer the question truthfully. Do you understand
Yes,
that?
sir.
That's when I swore you in at the beginning, that's what you were sworn to do. You just told me something that was not true.
I'm sorry, I misunderstood.
But how would
yes.
you misunderstand when I ask you a question that says, who owned the business? You said it was just Aurelia, and now it comes out that it's Mr. Velez as well. Do you understand
Yes.
how that affects your credibility? I can't really believe anything else you say at this. That makes sense?
Yes, sir.
So are you gonna tell the truth from here on out?
Yes.
Okay. If you don't understand a question, you can always say, I don't understand a question.
Okay.
All right, let's go and proceed.
and Ms. Mauricio, so your understanding as far as when the company was first formed, who were the owners of the company?
The owners were 50-50, Oralia Mauricio and Jared Velez.
Okay, and then later there was some discussion of Oralia transferring her ownership to you. Is that correct?
Yes.
But did that ever occur?
Your Honor, there's nothing in the Secretary of State that shows Angela
My
as,
understanding is that never occurred. You've never been an owner of this business.
Correct.
Is that true?
Correct.
And you're
Never
sure that's
been-
true?
From my understanding, yes, sir, when I talked to the CPA last, he never filed it.
So again, as of this time, Mr. Velez and Miss Mauricio are the sole owners, are the joint owners of this business, correct?
Correct.
So I guess I'm not understanding what you're trying to do. If he's a joint owner, why wouldn't he have the ability to take out loans if he's the joint owner?
because it was done without their knowledge. And they don't know what the requirements of that loan is. Do they pay it back? Will they,
What did the documents?
how the
say?
funds were used?
The documents that form this company, what did they say about the ability to?
There
take
is no
loans?
formation.
All right, do we really want to continue with this, or do you want to?
I have questions.
Well, I'm just trying to.
Your Honor, my client's fear is that she doesn't want to go to jail. She doesn't know what has been done with this EIN number, and she's, elderly, and she doesn't want.
And there's ways to deal with this, and that the company should be dissolved. If that's the concern, but. I mean, you guys created a company, got an EIN number, took out government loans with it. And there are no formation documents. There's nothing that prevents him as a co-owner from taking out these loans. I don't think this is the correct procedure. I mean, but you can go on. I'm just
Yeah.
telling you, I don't think this is the correct procedure. This company needs to be dissolved, that you need to go through the process of doing that. But you admit now that that wasn't what was said before, but he is a co-owner. He has even if he did take out loans, there's nothing that formation documents prevent him from doing that. As a co-owner, he could do it, right?
Yes, Your Honor, I do understand, but I do believe that there's a fiduciary duty that if he's gonna apply for loans that's under a company name that has joint managers, at least make her aware of applying for the loan where the funds are gonna be.
Let me just ask this, guys. Would you in the future, would you agree to an order that said for any loans in the future that are taken out by this company that you will inform her of that?
Actually, there's no reason to do that going forward, Your Honor. We have proof here also that Angela was paid off and said once she paid off her, the one.
So let me just tell you this. What is before me today? I have to decide what is before me today. What is before me today is they're trying to, as I understand it, trying to get a temporary injunction to stop to stop them from taking out any loans.
Taking out any loans, any additional debt until we're able to complete discovery to find
Okay.
out what has been done.
That's what we're here about today. Anything else really is,
And we're here to ask that you deny that. request.
that's not before me. I guess you're asking me not to do that.
To
Okay.
deny the request
Okay.
because we have also proof here, and I would like to question Angela if I'm able to.
Mhm.
In reference to her stating that Oralia is 50-50 owner of the company. However, in 2019, company taxes were filed by Angela and Jared Velez due to Oralia sending over the transfer to Angela of 50-50 ownership.
What does the Secretary of State's record say on this company? Who are the owners?
As of now, it's Jared Velez and myself.
The Secretary of State's records say that.
Yes, sir.
Let me see that.
Actually, we don't
I
have
have
that.
it with me.
Yes.
Okay, so I'm trying to come up with a reasonable compromise here, which is their
Am I able to
testimony.
question her though in
You
reference?
you can. But if you don't have the records that we have now, what do they say?
The records that we have now,
On who is the owner?
through the Secretary of State or what I am able to present to you as far as conversations being made.
But if she's not the owner, she doesn't have the ability to give away the interest, right?
Correct. But we also have message from Oralia stating, give Angela what she wants. Because she believed at the moment that it was transferred because Oralia has signed her ownership over to Angela.
And Your Honor, I don't want to use too much of the court's time, but we're just asking so that we can complete discovery to see if anything else was taken out and my client no longer be in fear of misuse of any government funds or any loans. And then we'd be more than happy to dissolve that injunction once those discovery documents, and discovery has already been propounded on the defendant.
We also, though, Your Honor, have the loan, the PP, there's no reason for them to fear that. From what I feel is because when we've applied for the PPP loan, it was 100% forgiven.
Okay, let me just tell you that there's a couple options. We can finish this hearing. There is a chance that we would issue an injunction against you, stopping you from taking any loans or taking any actions involving the company. I have to go based on what's in writing, and that not completely, but mostly what's in writing here. You don't have any, you said the Secretary of State says that
I didn't bring it. I do have it. I just.
then you can bring a future motion on that issue. But what I'm suggesting is testimony seems to be that the co-owners are Mr. Velez and Ms. Oralia, that you simply, are you planning on taking out any more loans on this company?
That's not what we're doing, Your Honor, but
But let me just
No,
answer my
no.
question. So all I'm saying is what I would suggest to give them peace of mind is you agree to, on the record, and we'll do a formal order, that if you do take out any of the loans, that you inform Ms. Mauricio before you do that. Can you agree to do that?
Yes, Your Honor.
yes, Your Honor.
Okay. All right. Can you agree to drop your temporary injunction then?
Yes, Your Honor.
All right. So let's make it clear on the record, the parties have agreed that Mr. Velez, before he takes out any more, or is it Mr. Velez, I guess?
Yeah.
Before he takes out any more loans, on the company, which the name is
Immediate Solutions LLC.
Immediate Solutions, that you will, that this is what the essentially the injunction or the order will say, that he will inform Ms. Mauricio at least 14 days. Is that good before the loan is closed? Is that fair?
Yes, Your Honor, you're saying that 14 days, I will inform them 14 days before applying for one on the loan? Is that
I
what you're
don't know.
saying?
How do you want to do this? Would it be better to applying or closing on the loan?
Applying, it's,
Okay,
that's
how
fine.
14 days before you apply for a loan?
Okay,
Does
that's-
that,
that's
does that
fine,
work
Your
for
Honor.
you?
That's fine.
All right, so you agree that you will inform her at least 14 days before applying for a loan. I would suggest strongly here that you guys, this is a mess, this paperwork, and this didn't get done and that didn't get done. There's a lot of blame to go around here, not so much, doesn't sound like to you, but to the way this was run, that you guys try to reach some type of agreement. Have you been to mediation on this?
no, Your Honor, we are set in, I believe, on June 18th for a scheduling order. I did bring a scheduling order today to see if we can be set for trial, and it's just a uniform scheduling order so that we'll have something.
Have you shown that to them?
No, I have not.
Why don't, that's something very normal, what she's trying to do. If you guys were attorneys, if you guys can agree to it, then I can sign it today. If you don't, then we need to have a separate hearing. So you guys, why don't you go back in the back conference room? We'll have Mr. Roberts join you. He's gonna be my proxy there to make sure nothing, so if it gets out of control, you can come get hearing, okay? You guys will go in the back conference room and talk about it, see if you can agree to the scheduling order. Why don't you write out this order? Let me just make it clear to you, though, if you violate this order and you take out a loan without telling her, then you could be subject to jail time and to a fine. So I just want you to make sure you understand that. You do need to comply with this order once I sign it, okay?
Yes, sir.
Does that make sense?
And Your Honor, the plaintiffs are asking for an accounting of the bank account that those funds from the IRS were received.
That was not set for today.
Okay. It was in our petition, but we will, can bring it up at a separate time.
All right, so you understand what's gonna happen. You guys are gonna go back there, you're gonna write out a copy of this order. You're gonna see if you can agree to the scheduling order. And if you don't agree to the scheduling order, that's okay. You don't have to, but it is something that's fairly normal.
And that's just gonna be us speaking with their attorney, right? We
Attorney.
do not want to speak to Angela or Oralia.
Let me ask this, how you guys don't get along, I presume, that's my guess?
It was my grandmother and she was my aunt, yes, sir.
Are you gonna be okay meeting with them in this back room, or do we need, should it just be with the attorney?
Just the attorney, I don't want to be around.
Okay, so why don't we do this? Brian and Bill, why don't you go back there? Brian, why don't you go in the room with, or both of you go in the room with them? We'll have, and who is this lady right here, the other lady?
Yes, that's my co-counsel. Co-counsel, Your Honor.
Okay, why don't you stay with your clients, you'll sit with them. Brian and Bill will sit with you. If anything gets possible, can get Gary and me, and but if it's that's all, that's your role, is make sure everything's okay. All right, are you guys gonna be okay?
Yes, sir.
All right, do you understand? And now if something blows up and you need to talk to me again, you're welcome to come back in here, and I'll talk to you again if there's anything we need to talk
Yes, Your
about.
Honor.
I think you.